Good evening. This is Laws 12062 Alternative Dispute Resolution. We're into week 2. We've got a number of people on the line, and what we're going to do tonight is talk about the opening statement for a mediator or conciliator. What I'm very keen to do is get people kick-started on the first assessment piece. Now, as I've mentioned to you before, I really want this to be a fun exercise. This is meant to be serious but fun at the same time. Now, the starting point is getting your lists, your groupings together. So I'm just going to share the screen for a moment and have a look at what we have already. You should be able to see a Word document. I can see the group members that have already been formed. Thank you very much for doing that. If you've already formed your group, please get started on it. And if you haven't, tonight might be an opportunity to kickstart that. If you're still looking for group members, please do a little bit more than just put on uCrew or send me an email saying I'm looking for a group. I need you to be proactive in that regard. And already tonight we've identified 2 groups with 2 people looking for one more. So if you're that person looking for a group, then maybe you can join Jimmy and Tamantha, or Bradley and Michelle, both looking for one extra person. So hopefully tonight we'll get that 3rd person organised. And just a big hint, Josh, you're on that list of looking for a group of 2, so that looks like a deal's got to be in there somewhere. Tonight I want to talk about the opening statement for a mediator and conciliator. And what I thought we should do is come up with some ideas using some words that might be useful as a building block to generate the ideas around the mediation and conciliation opening. So again, I'm going to share the screen once more. I hope this isn't too annoying, and we'll create a little document that we can put up on Moodle or uCrew. So this is Laws 12062 Alternative Dispute Resolution, new line, mediator/conciliator opening statements. We'll give that a heading and cap that. So what I would like is, now I'm not sure if I'm clever enough to do this, I want to share the screen, but I also want to have a look at the chat facility. I can't see the chat facility easily, so what that means is I might have to get you to come in and say some words that we can add to this. In fact, what I'll do is I'm going to stop the share. We'll do it this way. In terms of Cap setting the mood, can anyone give me some words? Either unmute your microphone and tell me, or use the chat facility. I'm just after some words that describe what you should do to set the mood or set the scene for the mediation or the conciliation. And I'll jot these down. So let's go. I want you to describe what's important in a word about setting the mood or setting the scene for the mediation. Who wants to come in and volunteer a word?
Let's start with welcome.
I would say that to thank the parties after welcome, to thank the parties for attending the meeting. I would think that we gathered together, yes.
Do we have some more? What about the seating arrangements? Sorry, did I cut someone off there?
Introduce yourself.
Thank you, that's excellent. So introduce yourself And what do you have to do when you're introducing yourself? What's important about that?
I think shaking somebody's hand is, to be honest, myself.
Yep. So shake the person's hand. What you're trying to do is create an atmosphere where people feel that they're being welcomed into something. So shaking the person's hand. And so that's part of the non-verbal, isn't it? What else do we need to do under the heading of providing a welcome and setting the scene? We've talked about introducing yourself. What should you do apart from just saying, hey, my name is such and such? Is there anything else that you want to do in those early stages?
Allocate seating. Oh, sorry.
Allocate seating, yep. And I can see that the chat facility is going crazy and I've been ignoring it. So I'll go and have a look over there as well. Cap, allocate the seating.
Let's make sure we've got the right clients and the right dispute and in the right room.
Yeah. Check for practicalities, dash, right dispute, right people. That makes a lot of sense. Okay. So there's just looking at the chat facility, there's a lot there. We're going through people are forming groups. That's good. And arrange the seating. Yep. Let me just jot that down. Cap, arrange the seating, new line. Explain impartiality. That's really important, but we might do that as part of the opening statement. Identify problems in private. We'll have a look at that too, Josh, as part of the opening statement. Impartiality is getting a few votes. That's good. Make sure everybody knows their role. Amenities. Yep. Talk about the amenities. All right, that's good. Let's now move on to Cap, the opening statement. So what do we need to talk about in the opening statement? What are some important words here?
Boundaries.
So the word is Cap, boundaries. Is that what someone said?
Yes.
Okay, thanks, Melissa. What else do we need to do? Just give me some words for the opening statement. We've got Cap, outlining issues. Yep. So what does that mean, Melissa? Michelle, outlining issues. Do you want to elaborate on that?
I think it sort of means setting the parameters of what the discussion is about, because if you fail to do that in the beginning, people might be at cross purposes.
So outlining the issues, dash, make sure that the parties are starting to focus. All right. Now we've got a note here for Cap, ground rules, e.g. language, etc. Thank you, Grace, for that contribution. What else do we need to do in the opening statement?
What about explaining a little bit of your background and your experience?
Explaining your background and experience. I think that's excellent. And you want to ensure that you've got some credibility. So that's a good way of doing things. Okay, so setting some boundaries, outlining issues, ground rules, explaining your background. What else do we have? What else do we want to say or communicate during the opening statement?
Are there some procedural things that you have to say at the outset?
Mm-hmm.
That it's without prejudice?
Yes.
So anything said in the mediation can't be brought up as evidence at the trial or something to that effect?
Okay, and that was, I can't see who that was speaking, but it's very good.
Sorry,
Who
it was
that?
Michelle.
Michelle. Oh, there you are, Michelle. Sorry. There's plenty of people on my screen. Cap, without prejudice. What else do we want to say? Give me some words. I'm not looking for an order necessarily at this stage, but just some words.
Would you ask them to participate in good faith?
Yep. So, participate in good faith. Very good. Did someone mention impartiality before? Cap impartiality. We'll put that down as well. Time limits. Cap time limits, new line. Cap explain that you are there for the best interest for both parties. Yep. What else do we want to talk about? Or mention? What about the Cap, the process? What would you talk about in the process? We'll make that a subheading. So if we were describing what happens in a mediation or conciliation, what happens first?
I guess you'd probably select one of the parties to discuss their options first, I guess, or their feelings, or why they're there, or their point of view.
Cap opening statement. Okay, yep. And excuse me a sec. Things have gone seriously wrong here. I've got a new version of Dragon, and I haven't yet taken off the command module for it. What that means is it's now typing in Greek. Seriously. Opening statement. I'll just check that again. Yeah, there it is. It's in Greek. Okay, we'll come back to that. I'll make some notes and I'll write it up later. So what's involved in the opening statements for both parties? How long do you want them to speak? Should you tell them that? Give them some idea?
I guess it depends on the mood of the dispute. For example, you might want to keep it very formal and very strict time limits. The type of people there may be relaxed enough to go, okay, well, if we go over a little bit, that's okay. And I guess it depends on the parties in the dispute.
All right. So would you be inclined to set, say, a time limit and say, all right, well, I'll allocate you now up to 5 minutes for your opening statement? Or would you be inclined to say, I'd like to hear from the parties in their opening statement, but at this stage, just something fairly brief? So which way would you be? I guess it depends on the level of how prescriptive you want to be.
I'd leave it open to the parties more or less, but give them some sort of guidance. Say, let's keep it brief, but in your own words and in your own time, you tell me your side of things.
Okay. So, and as Jason said, that might be a matter of determining the mood and the nature of the dispute. After you've said there's an opening statement, would you invite the other party to respond with their opening statement, or would you discuss what the first party said initially and then go to the other side? Which way would you prefer to go?
I would think that you'd give the other party a chance to say their piece. Otherwise, they're going to feel like the first party is getting all the time and getting all the attention and no one's listening to their needs as well. So I think you create a level playing field if both sides get to have their say straight up.
Yeah. Are there any other views on that point? Michelle says, let both parties have their relatively short opening statement initially before we discuss it. Melissa, I agree with Michelle. Vote of hands. Who agrees with Michelle on that one? I do. As soon as I put my hand up, you put your hands up. I saw that. All right. No, I agree. I think that's the way to go. It's very important that you don't let one party feel that they're irrelevant to the process. So engage them initially first up. Okay. Now, Josh, you've come up with a really good idea. Do you want to tell us about that one? Do you want to unmute your microphone, Josh, and tell us?
Can you hear me?
Yeah, we can hear you fine.
Sorry, I wasn't sure if it was working or not. I suppose if there was a whiteboard or some sort of apparatus present, everyone's statements or arguments get to be put into something that's visible by all parties. So I suppose it's a level playing field, so to speak.
Mm-hmm. Any comments about what Josh has suggested and why?
I think it's a good idea. I think it reinforces that the main things that everyone's saying is being heard and being sort of recognised. Although I do wonder if it would possibly distract in some scenarios.
Mm-hmm.
I can't think of a specific example, but I think people might get caught on certain things.
Yes. So you'd use a whiteboard, but perhaps consider it may be distracting. Are there any other views about the use of a whiteboard in a mediation session?
Do you run the risk that you'd put something on the whiteboard that would stick in someone's mind so they wouldn't be able to get past that if they were, if it was something that was bothering them and they saw it, it's in, like it's cast in concrete on the whiteboard?
So it could inflame the issue or distract the parties? Is that what you're saying?
I guess, if it's a point that one party's willing to give on, having it on the whiteboard sort of says it's there permanently, so it doesn't let them negotiate with it to some extent.
All right. So you're suggesting, if I've heard you correctly, that the whiteboard's a good idea, but provided both parties take ownership of it to some degree.
Yeah, I guess so long as it's not. So long as things on there are allowed to be taken off, I guess that would be important to me.
All right. Can we hear from maybe Katrina or Chloe? What do you think? You love that, Katrina, I could see. But what do you think is important? What sort of thing would you put on a whiteboard? Why, as opposed to a piece of paper? Or is there any difference? Would you put the same things on a whiteboard as you would a piece of paper? So Jimmy suggested that Josh has suggested we use a whiteboard. What would we put on that?
Maybe the main issues.
Issue. Oh, I love that. That's a great word. The issues. Okay. And Josh, is that what you had in mind? The issues go on the whiteboard?
Yeah, it'd just logically thinking it through in my head. So you'd have the issues up the top. So you'd be working off some sort of structure like a problem, pain and challenge sort of thing. So you'd have your issues up the top, work out what your obstacles were, and then try to sort out some sort of negotiation and conclusion down the bottom, I guess.
Okay. Thanks, Josh. Chloe, if I was to suggest the word agenda might be a good heading for things on a whiteboard, would you agree or disagree with that? And alternatively, if Chloe's not around, maybe Andrew or Stephen, what do you think? Do you think agenda is a good heading?
Yeah, I think agendas. Can you hear me?
Okay. It's a loaded question, isn't it, Andrew?
Can you hear me? Can you guys?
Yep, I can hear.
Yeah. I think agenda is a very good, heading to put on a whiteboard just because it's visible for everyone to see. There's a procedure in place that people can follow. Mm-hmm. So you can even sort of number it from 1 to 5 or 1 to 10, depending on how many agendas there are in the discussion at hand.
Okay, thanks.
Yeah.
All right. So Stephen or Chloe, do you think having 10 items on an agenda is too many, or do you think that's workable?
I think it's a lot when you have to be working backwards and forwards with two people trying to reach an agreement on 10 individual points. It just seems a bit excessive when ideally they should be agreeing what the agenda is to start with. So if there's 10 things to discuss, it sounds like things might have gotten too far off track already.
Yeah. No, I tend to agree with you, Stephen. I work as a rule of thumb, I usually work towards somewhere between 3 and 5 items on an agenda. Beyond that, it starts to get a bit exhausting for clients. That's not to say that that's right. That's just my personal view. So coming back to Andrew's point, maybe it depends on the nature of the dispute as well. So if we're talking about something that is likely to involve a mediation that takes all day or 2 days, maybe a multi-party mediation or conciliation, then that might be a different kettle of fish to one that is scheduled to take 15 minutes, for example. If Kylie has any thoughts, or Chloe, please let us know. So we're talking about a suitable number of agenda items for discussion. Okay, so having set out the importance of an agenda, what else do we think? What else do we need to discuss during the opening statement, or the opening statement, when we're giving a statement to the parties and we're trying to describe what they're going to be saying, sort of what they'll be doing in their mediation? What else do we need to talk about in that opening statement? The process of the mediation. Yep, absolutely. So.
Do you explain that you're not the person who makes the decision, that they have to reach their own decision? You're just there to facilitate discussion?
Okay. Yep, absolutely. And Katrina, you've correctly said what we're doing. Melissa, what do you think is the sort of the order that the mediation or conciliation should take, if you were describing it?
Perhaps you would have an introduction for yourself, and then maybe opening statements by the parties, and then you might say, then we'll have a bit of a group discussion, then we might move to private discussions, and then we might come back together and see where we're at then.
Okay, perfect.
Something to give them an idea of where they're going and how it's going to run, so there's no surprises. Everyone knows where they stand and what they're going to be doing.
Okay, very good. Excellent. Let's do it this way. Let's pretend I'm the mediator. It's my very first mediation, so I don't really know what I'm doing, but I'll give you a draft opening statement. This is not the model mediation statement. This is me taking a dive for a sec. Good evening. I'm the mediator, and we're here to mediate your dispute. Now, is there anything you want to know about the mediation? Has anyone got any questions for me about today's mediation before we start? Too brief? Yeah, no, that's a comment. But no, seriously, pretend you're in a dispute and I've been appointed as the mediator for the dispute, and I say, well, hello, I'm the mediator and I'm here to mediate the dispute. Okay, well, let's start with any questions. Do you have any questions about what we're doing here tonight? If you're a participant, would you have some questions to ask me about this mediation? And I'll come back and explain what the difference is between mediation and conciliation later, Josh.
I don't think I'd engage with you very well. I don't think, as the person that's supposed to be in power and telling us what we should do next, you haven't given us your name. You've just told us you're a mediator. You don't tell us what a mediator is.
Okay.
And you've given us nothing to ask the question about.
All right. So if I was doing a good job as a mediator, I would empower myself and the parties, and I would provide an introduction of my background. Was that what you were saying, Michelle? Okay. What else would you Well, what else would you like to ask me? I'm the mediator. Ask me anything you like about the mediation. So the plan for the session. So for the session, so I should really explain what's involved in the session, the plan, the process. Okay, I've got it. All right, so I'll be a much better mediator. How it'll be broken up. Okay. Well, I can tell you how it's going to be broken up. And firstly, I'll let you know, by way of introduction, my name is John Milburn and I'm appointed as the mediator for this dispute, and this is my very first mediation. But I will tell you about my background. I'm a lawyer and I practice in litigation, and now I'm going to start practicing in dispute resolution. The plan for the session is I'll provide this opening statement to you, then I'll hear from both parties. While you're presenting your arguments, or so your opening statement, I'd ask that you please be brief, and I would ask the cooperation of the other party to remain silent while the party giving their opening statement does so, and then I'll hear from you. But do make the opening statements brief. After we've had the opening statements, we'll then go into a general discussion, a round table. We'll see if we can generate some ideas and some options. And in all likelihood, we'll break into private sessions after that, where I'll talk with each of you in turn. And anything that you tell me during those private sessions will remain confidential between us. I won't pass that on to the other side. We'll then come back and have another discussion round table and hopefully come towards a resolution. So that's the plan for the session. Now, what else should we... Is there anything else that you want to know about this mediation session? Katrina, you've come up with a good idea, something that I should be telling you about.
The experience and qualifications.
You want to know about my experience and qualifications, and you want me to tell you about confidentiality, is that right?
Yes, confidentiality.
Very good. All right. Oh, I should tell you, I forgot to mention, this process is confidential in that if the matter does go to litigation, offers of compromise, concessions that you might make during this session remain confidential to the session, and you can't raise that in later litigation. In terms of experience and qualifications, yeah, I'm a lawyer and I'm just starting out in mediation work. But I like that point of confidentiality. Now, Michelle, you want to ask me something about payment or tell you something about payment, is that right? So in terms of the payment for my fees, that's something that has already been arranged in the mediation agreement, which I should have said. I didn't send you the mediation agreement. All right, well, I have the mediation agreement here. I'll get you to read through that and you'll see that my fees are to be paid jointly. But I probably should have raised that in a part of an intake process and sent you the mediation agreements and made arrangements for you to pay half the fees, my fees, into my account in advance. But thanks for mentioning that. I should have mentioned that. Is there anything else that I need to tell you in the opening statement? What haven't I told you? Now, based on what I've told you already, how long is the mediation going to take?
I was just going to say time, how long you had for the mediation.
Yes, thank you. Oh, yes, I meant to say, the mediation session I expect will take in the order of 3 hours. Sometimes the mediation may be 2 hours, it may be 4 hours, sometimes it's much longer. But at this stage, let's work towards 3 hours as being an average time for a mediation. So it's important that I establish that you're aware of that and that you have no time constraints. If anyone has a time constraint, or they expected the time period for this mediation to be different, please let me know now. I'm glad you've reminded me. I meant to tell you that in the opening statement. What else is there I've got to talk about in the opening statement? Nothing else? No other questions? All right. So what we're trying to do in this exercise is get you thinking about what you're going to be saying in the mediation. Okay, the outcome is not binding unless it's arbitration. Oh, right. Yeah, I should have said that I'm not here to act as a judge or jury. I'm not here to make a determination. And depending on the nature of the mediation or the conciliation, it may be binding or non-binding. The ones that I'm involved in, I encourage the parties to come to a binding dispute. So that might mean that there's a discussion about whether they wish to contact someone or they have authority to make the agreement. All right, so thanks for that, Josh. Are there any other questions that you have of me, of the mediator, or is that it? We're all good? Now, based on that, does anyone want to volunteer just to give me a quick off-the-cuff introduction as if you were the mediator, because I'm sure you could do a much better job than I did in that session. Anyone game enough to just give us a 30-second opening as the mediator? You've got some points now. Let's put it into practice. Imagine the kudos if you were the first one to say, I'll give it a go. I'm looking for the unmuting of microphones and I'm getting nothing. I'm getting a lot of no thanks and ha-has. I think we can do better than that. No one's willing to give it a go? All right. Well, what we'll do is, what if we make it a progressive thing? We'll just go around the table and you can add just one more thing. How does that sound? So just think for a moment. I'm just going to give you 5 minutes to jot down some words or some phrases that you think will be important as a mediator. And what we'll do is there might be a volunteer after that, or we might go around the table or go around the room. So the exercise is this: 5 minutes to picture yourself as the mediator, and you need to provide an opening statement to the participants. I'll leave and I'll come back in 5 minutes. Okay? another 30 seconds or so. All right. Well, thank you for going through that exercise. What you've done there is gone a good way towards what you need to do for the first assessment piece, of course. So with your first assessment, you'll need to set the scene with your opening statement. That's what we're working on now. So we'll go around the room and I'll get you to just say a few words and then we'll move on to the next person. So when you hear your name, if you could just add a little bit more to the conversation. Is that okay? All right. So opening statement for a mediator or conciliator. Grace.
Good evening. My name is Grace Randall and I'm the mediator for this session. I am new to this process, but I will do my best to help both parties.
Thank you, Grace. Michelle.
Thank you both for attending tonight's mediation. I know that you have seen my fee agreement and half of the fees have been paid by each of the parties.
Thank you. Melissa.
I'll just say that I'd like to make sure you're both aware that anything we discuss today will remain confidential and yeah.
Thank you, Melissa. Jimmy.
I will talk about the outcome of the mediation. We'll try to make a binding for both parties in case litigation going on after the mediation.
Thanks, Jimmy. Andrew. You just have to unmute your microphone, Andrew.
Hi, my name's Andrew, and I'll be a mediator for today. Please find refreshments located in the corner of the room. Yeah, please come in.
Okay. Thanks, Andrew. Katrina.
I would say today's session will be 3 hours. Has anybody got any time limitations for today?
Thanks, Katrina. Jason.
I'd add, excuse me, today's mediation will start with opening statements by each party, and I ask you to respect the speaker by way of silence. This will allow both parties to highlight the key points to their dispute and serve as a foundation to the process here today.
Thank you, Jason. Kylie.
Following the opening statements, I'll briefly summarise the main issues that each party's raised, and we'll move into further discussion of those matters. If necessary, we'll break into individual private discussions. If they're necessary, the private discussions would remain confidential between the party and myself, and then after those we'll come back together for further discussion and hopefully resolution.
Thanks, Kylie. Josh.
I think all that's left after that's good luck. But everything I had written down's been said, so.
All right. Thank you, Josh. Stephen.
The only thing I had that hasn't been said was, does anyone have any questions for me before we proceed?
Okay, no, thank you very much. We'll keep going. Grace, back to you.
By the end of today's discussion, I would encourage both parties to have a binding agreement.
Thank you. Michelle.
My role is to generate options, but you have to be the ones to make the decision. And you can terminate the mediation at any time, as can I, if the parties reach an impasse.
Thank you. Melissa.
If either of you feel like you'd like to take a short break, that's fine. Just let me know and we can have a 5 or 10 minute break.
That's good. Jimmy.
I think it's all covered. I don't have any more to add on.
No, that's fine. Andrew.
So after obviously welcoming them, I'd ask them, so how would you like me to address you? And just be advised that I'm here to help you negotiate a suitable outcome.
Thank you. Katrina.
Today, I will not be giving you any legal, financial, or other specialised advice. I'll just be here to be your mediator.
Thank you. Jason. Unmute your microphone, Jason.
I think I'd start by saying, Mr. Trump, since you started this mediation, I'll invite you to go first. Ms. Clinton, you can go second.
Okay, thank you. Now, Josh, you're out. Stephen.
Everything I had was covered already.
Okay. So I'm writing. Once you say that, you're out. So we'll keep moving on. Gordon, I know you've joined us late. We're just looking for things that you might say during the course of an opening statement. Do you want to join in?
I'll pass on that at the moment.
Okay.
From civil procedure.
All right. No, I understand. Thank you. All right. Back to Grace. Anything else we're going to say, Grace?
I probably would like to advise the parties to focus on the options and on the solutions rather than on emotions during the whole process, to enable to clear the minds and move on rather than stay with the emotions of the parties.
Thank you. Michelle.
They should be advised of their right to obtain legal advice, and that they ought to obtain legal advice at any time throughout the mediation if required.
Thank you. Melissa.
I think I'm out.
You're out?
I'm out.
Andrew.
Yes, I'd advise them that if they haven't been ordered to attend the mediation, this is a voluntary process, and it's not meeting their needs and they're free to walk at any time.
I like the word voluntary. Thank you. Katrina.
Hello?
Yes, Katrina.
I said I think I'm done also.
You're out? Okay. Kylie.
I'd like to check that everyone knows everyone else who's present and why they're here, like if they brought their legal representatives with them, etc.
Okay, thank you. Jason.
Depending on the mood and the tension in the room, before I invited Mr. Trump to speak, perhaps I could organise a cup of tea or coffee for the parties, just to give them a few moments to compose themselves and prepare for their opening statement before we begin.
Well, thank you. Grace.
I think I'm out.
Grace is out? All right, thank you. Andrew.
I'd probably tell them that they're entitled to an impartial or a neutral mediator,
Yep.
and that if I know any of the parties, I should probably disclose it because there might be a conflict of interest.
Okay. Yep, disclosure. That's very good. Kylie?
Just checking everyone's comfortable with the temperature of the room and seating arrangements, etc.
Okay, thank you. Jason?
No, I'd want someone to start talking now. There's been too much wasted time anyway.
So, all right, we'll that's fine. Michelle?
Finally, before Jason continues, I would ensure that the observers and supporters have signed confidentiality agreements.
Okay, yes, confidentiality. I like that. Andrew?
I think I'm out.
Out. Kylie?
Yeah, I'm done.
Okay, down to 2. Jason?
Michelle's the clear winner, John.
Okay, good on you, Michelle. Oh, round of applause for Michelle.
Do I get
Well
some sort
done.
of prize of chocolate?
Well done. All right, so look, just completely off the top, can I just give you a really quick idea? And it may be that some of the things I'm about to say we didn't catch in that little round robin, but if I was the mediator, I might say something along these lines. Good afternoon. My name is John Milburn. I'm the mediator appointed by the tribunal to assist the parties in coming to a resolution of the dispute that we have before us. It's important that we set the ground rules and also provide you with an explanation of the process. The mediation session typically will take in the order of 3 hours, and I do hope that you've allocated that time. If you have any time constraints, please let me know. My name is John Milburn. As I mentioned, I'm a qualified lawyer. I'm also a nationally qualified mediator. I have conducted many mediations of this type in the past. Firstly, can I thank you for attending today? I know that it can be difficult to confront each other, even in an environment like this, but it is important that you've come today with a view to resolving the dispute, which is really your dispute. The importance of a mediation session is that we can generate together some options that might serve to resolve the issue without going on to litigation. Bear in mind, of course, that in this session, we can make whatever agreement we like to resolve the issue. If we press on and go to litigation, the decision is taken out of your hands and it's imposed, given by a third party, and a decision is imposed upon you. In other words, there's not the flexibility that we have today. So if we're inventive, we might come up with some different ways to resolve this dispute that would not be open to a tribunal member hearing the matter in a final hearing. This process is confidential. Now, it's a very important part of the process, and what I mean by that is that the information that you say today by way of a settlement offer, a compromise, or something that you might say working towards a resolution, remains confidential to the process. You can't raise that in later proceedings. So feel free to come up with an idea, make a compromise offer of something towards a resolution, because it won't come back against you in the final hearing. Now, the procedure is that I'll invite each of you, both of you in turn, to provide a brief opening statement. From those opening statements, we'll form an agenda. I would ask that you please respect each other's privacy during those opening statements by remaining silent when they do. Now, the importance of an agenda is that it gives us something to work towards, and I'm going to be looking for an agenda of maybe 3 or 4 items, and we'll discuss the items around that agenda. We'll do that in an open discussion, a roundtable discussion, after we have the opening statements from both parties. And typically in a mediation session, after the roundtable discussion, I'd go into private sessions. And what that means is that you and I individually will chat, and anything that you tell me during that private session between just us remains just between us. I won't pass it on to the other side. We'll then probably come back into another roundtable meeting and hopefully work towards a resolution. The whole entire process is confidential, and we have that confidentiality within the private sessions as well. So I take it that each of the parties have authority to settle the matter today. Is that correct? Yes? Yes? All right, good. If you do need to take a break, if you need to get some legal advice, if you need to speak to someone else, please let me know, and we'll work towards allowing you to have that opportunity. At the end of the session, I'd like to commit any agreement that we have to writing, and I have the ability to make that into an order today, but in any event, it would be nice if we could resolve it through some sort of formalised agreement. The process is likely to take in the order of 3 hours, as I mentioned, and I think we should start now. All right, so that really wasn't a very good job. I must make some notes for myself next time, and I'm sure that there are things that I've missed. There may have been a few things that I covered that weren't covered in that round table that Michelle won previously. But if you do come up with some ideas, some words, some phrases, things that we haven't discussed, then feel free to share them on UCrew or somewhere else. But the importance of tonight's session is that by now, you should be just about getting ready to finish your opening statement, ready for your first assessment piece. All right, are there any questions about what I said or what we've tried to achieve tonight?
I have a question. I wasn't timing you then, but that seemed, I don't know, 6 or 7 minutes. Would you think that the majority of our assignment task is basically going to be the opening statement? How far do you think we'll get through?
That's a really good point, because I think the opening statement to some degree is reflective of the nature of the dispute and the length of the likely dispute. So an opening statement of that length for a 3-hour mediation, that's fine. But when you've got 15 minutes, and with the assessment piece, don't worry, if it goes beyond 15 minutes, that's fine, but just not too long. You'll need to make it quicker than that. So it might be that you can condense that much more than I did. And mine was a bit waffling, I'm sorry. But that's a good question. Thank you, Michelle. Any other questions or comments? Yeah, sorry, Michelle.
Sorry, I'm taking up all of your time.
No.
How far through the mediation process do you expect us to get in this assessment piece?
Realistically, I don't expect it to be resolved. If it is resolved, fine, but it shouldn't be too artificial. Given that length of time, it probably won't be resolved. And if you explain the process during that session, then if you don't actually get to joint sessions, I understand. If you have time to get to joint sessions, fine. To private sessions, fine. But you probably won't get to private sessions or that second roundtable discussion. And within that time frame, you know, we're looking for different attributes that you can show me, and it may be that depending on the circumstances, you might have some parties that are very hostile immediately, and you know, the whole 15 minutes might be trying to settle the parties down. But if you can showcase a few different skills during that time, that would be excellent. Thank you, Michelle. No, they're good questions. Any other questions or comments?
I have one. Because it's just a short mediation, how should we end it, given, you know, we might not get the whole way through it? How would you like us to finish it?
It's fine. You can finish it abruptly if you like, by just sort of turning to camera and saying, you know, thanks, John, but that's probably that might do, or something along those lines. So I don't mind if it ends abruptly. But if it's going well and you thought, well, it's supposed to be 15 minutes. If it's 25, that's okay. If it's getting more than 25, that's too long. So if you're at the 15-minute mark and you think, oh, I might be able to resolve this if I go another few minutes, then go the extra few minutes. Otherwise, just call it off. Just say, well, thank you. That's a good question. Any other questions or comments?
Yeah, John, I've just got that question again about the difference between conciliation and mediation.
Yep. A conciliation is a mediation with muscle in some ways, in that it still follows very much the format of a mediation, but a conciliator has an ability to advise the parties, and quite often that's done during a private session. In some mediations, for example, in some conciliations, like the ones that I do for QCAT, we go a bit further, and I've actually got power to make orders. So in a conciliation session, I would be involved at some stage, almost invariably, in providing some advice to the clients. That's not, I've got to be careful and I'll come back and explain that, but there's an advisory role, and there's also a role to make orders. So I might say, well, we'll make some directions at the end of it. We haven't resolved it, but I would like affidavits exchanged within 14 days, and we'll appoint an expert, and we'll have a hearing. When I say advice, your role as a mediator or conciliator is not to take the place of a lawyer. You're not there to determine the dispute. You're not there as a judge or jury. I should have said this in my draft opening, so add that in. There's a lot of stuff I didn't say in that opening. You're not there as a judge or jury. You're not there to advise the party specifically, but you can give some advice in more general terms to the parties. And in private session, you might say, look, I understand your arguments, but please remember, of course, that you're going to have to prove these things. And the court may not accept the evidence in its current form, which is really hearsay. So it's sort of more that type of advice, more than saying, I've considered this matter, and if I was hearing the matter, I would award $15,300 for this reason. It's not that sort of advice. It's more in terms of reality testing and advising that it's maybe may take a long time, and it may be a very difficult task. So a mediator can do that as well, but as a conciliator, you're taking it a step further. I hope that.
Sorry, just to add a little bit onto that. So as a conciliator, you can't actually say, well, I've heard a matter like this previously, and this was the outcome. To hurry things up a little bit, can we just go down that track?
Look, I think the first part, carefully, is okay. The bit about hurrying up, I'd use that very cautiously.
Yeah, that was a bit crass. Sorry about that.
No, you're right, Josh. That's good. But no, the first part I think is fine.
Okay, beautiful. Thank you.
All right. Ricky was saying in the family law situation, mediation is not to give advice. Yep. And that would not be essential in a family law mediation. Yep. In its pure form, a mediation is non-advisory. It's really there to assist the parties. And in a really pure form, the mediator doesn't even involve themselves in trying to generate options for consideration. All right, now I'm conscious we're after 7. I know some people have to go to different things, but are there any other questions or comments? And thanks, can I just say thank you very much. Sorry, Michelle.
Sorry, my question was, obviously you just described sort of a gambit of mediator. What kind of mediator are you looking for, or are you just open to one that's sort of somewhere between mediator and conciliator, or are we identifying we are a strict mediator versus a strict conciliator?
I'm really pleased you asked that question. The idea of the written material to accompany the session is for you to tell me what model you're using. So in the written note, you should say, look, the scenario, it's a family law dispute. It's to do with property. I'm taking the role of a conciliator, and, you might go on a little bit further and say, you understand the husband's grumpy and the wife is not, or something. You can do a little bit more elaborating, but the idea is to call it as the way you're going to present it, and then I can match what you've done compared to what you said you would do. That's part of it. Thanks, Michelle.
Sorry, and another question.
No, it's good.
I've noticed a lot of the stuff only refers to mediators. Is it the case that further on in the book it's specific things about conciliators' rules, or is it that conciliators abide by the same rules as mediators? They just have a different kind of role?
It's very similar. There's a different focus. I think there is a chapter on conciliation. I don't have the book in front of me, but I'd certainly read them both. But many of the rules relate to both. And the whole thing about negotiations, body language, reframing, all those sorts of things, they apply to both. Thank you, Michelle. Any other questions, comments? All right. Well, we might wrap it up.
John, I've got a quick one.
Yes.
My internet connection's terrible tonight, and I've dropped out a couple of times. Where do I go to watch the recording?
I'll upload this through YouTube and then onto Moodle and uCrew. What I do is I upload the recording into the week of Moodle. So if you go to week 2, you'll see the recording there. And usually that will be by tonight. So last week's is already on week 1 in Moodle, but I also put it in uCrew. Okay. Has everyone's been able to find it so far? It's good. All right.
No, I couldn't find it. That's why I asked the question.
Okay. Thanks, Kylie. Yeah. So, and I'm conscious I do need to simplify my Moodle site. Next year's offering of this course, the Moodle site will be stripped back to basics, but bear with me while there's lots of material there. But please provide your feedback as well. All right. Well, thank you very much for thanks for your participation. Well done, Michelle. You're the winner tonight. And we look forward to seeing you next week. I'll be on a laptop next week. I'll be in Brisbane, so it might be a short session. So all the best. I'll end the meeting now.